Hello and welcome back to EasyTexasDivorce.com. Today's video is going to be about the best interest of the child test. So if you've been involved in a custody case, you're going to know that term. And what that means is basically what this case on the screen is about. But before I jump into the case, we have to remember that the legal standard in evaluating the best interest of the child test is something called the preponderance of the evidence test. It's the same legal standard that we use in civil cases for all sorts of different issues that come up, like car accidents, like a breach of contract. And so what that means, preponderance simply is defined as something being more likely than not to have occurred. So in this case, the best interest of the child test would be it's in the best interest. It's more likely than not that the child's best interest is served by being with either dad or mom, depending on which party is making the argument. And so there's actually a famous case from 1976 called Hawley v. Adams. And in that case, which is cited frequently even to this day, the court lists out a few other items that the court will use to evaluate the best interest of the child test. And so I'm just going to go ahead and jump into this case and jump into the part where it talks about the best interest test. And so it says an extended numbers of factors have been considered by the courts in ascertaining the best interest of the child, including among these are the following: the desires of the child, the emotional and physical needs of the child now and in the future, the emotional and physical danger to the child now and in the future, the parental abilities of the individual seeking custody, the programs available to assist these individuals to promote the best interests of the child, the plans for the child by these individuals or the agency seeking custody, the stability of the home or proposed placement, the acts or omissions of the parent, which may indicate that the existing parent-child relationship is not a proper one, and any excuse for the acts or omissions of the parents. And it goes on to say that this list is by no means exhaustive, but does indicate a number of considerations which either have been or would appear to be pertinent. And so these are some factors to consider when you're prepping your case on custody. See you next time.